Hi, this is elder law attorney Melissa O'Connor. I create estate Medicaid plans for people in Florida, and I do probate, and I do it well. Today I wanted to talk to you about steps to take before you open a probate. But before I get to that, I wanted to invite you to schedule a free strategy session with me at eldermeeting.com. Okay, so many times families will call me because their loved one has recently died and they have a sense of urgency since they were named as the personal representative or the executor in the will. They went online, they asked AI or Google, what are they supposed to do? And they were told they needed to deposit the will within the first 10 days of somebody passing, and they get a whole list of all the steps that they need to do. And while it is true that Florida law does say that a person in possession of a last will and testament is supposed to deposit that will, the original will, with the clerk of court in the county in which the person resided, that's true. But that does not mean that you have to rush to open the probate estate at that same time. I usually recommend families, one, you want to mourn, right? Because you just lost a loved one, and we don't want to ignore that. That's a really important process in your emotional state. So we don't want to distract ourselves from the mourning process by getting busy with all this legal work, which many people would like to do. The other reason why we don't want to just rush is because we want to kind of take an assessment and an inventory to determine, one, do we even need a probate? Did our loved one die with what they call probate assets, meaning assets that are titled only in their name, that require the probate process to have title to transfer from the name of the dead into the name of the living? So one, we want to know, do we even have probate assets that need our attention? Two, we want to pay attention to potential creditors, okay? We want to know how much do we have in probate assets and how much out there in exposure do we have to creditor claims? Because we want to make an informed decision. Are we going to open up this estate for the sole purpose of paying all the creditors? If that's our goal, I want us to know that when we're going in and not be disappointed when we get there, where we thought that folks were going to be able to get an inheritance of any size, big or small, and then they find out that all of the effort and all of the funds were gobbled up in creditor claims, and they wondered, why did I go through this whole hassle just to pay these creditors? That seemed like a lot of thankless work on my part. So I want people to know exactly what they're getting into, because there is the opportunity to just pause and not open the probate. There's nothing that says that you need to open the probate or that you need to open it today or this year. There is a 2-year statute of limitations on creditor claims in Florida. So sometimes people want to be strategic about it because they realize that the amount of money that they have in probate assets and the amount of creditor claims don't make this a cost-effective process. However, if they wait 2 years for the creditor period, the statute of limitations to run, and they open up the probate at 2 years, 6 months, then the creditor's opportunity to get paid is statutorily barred. And those monies now are available to the family to be dispersed pursuant to the terms of the will or pursuant to the terms of the intestate statutes. So that is a strategic maneuver where you say, okay, we have some money but not enough money based off of our asset to debt ratio here, and so we're going to be strategic about it. So these are just some of the reasons why you might want to take a pause before just immediately opening a probate. And a good probate attorney would ask you these questions at the intake and help you make that informed decision. So that way you wouldn't get the whole process going and then be utterly frustrated and disappointed. So the goal always is to just know what you're getting into, because the probate process can be complicated. It doesn't have to be complicated, but if you go into it having clear expectations, that usually makes the process feel smoother and not so complicated. It's important to have a good guide and to be thoughtful about the steps you take and the timing in which you take them. If this information has been helpful, I ask that you like and share with others. And as always, you're welcome to schedule a strategy session with me at eldermeeting.com. Thank you.